We know when to go to court, and we know when to stay out of court. And sometimes the reasons to go to court are simply because there's a genuine question of law or fact, and sometimes it's because the other party will not be reasonable, and we have to go to court to defend our client's rights. But most of the time, all we need is facts. The more facts we have, the easier a particular issue is to settle. People can see it logically. Both parties, even if they're very bitter towards one another, can see it logically and make the right decisions on those sorts of things. We find that many times the best way to protect the children in a given marriage is to negotiate the issues regarding the children outside of court. Litigation is a tricky field of law. It's something where you have to respond quickly, act on your feet, make minute decisions from point to point. But the toughest thing about litigation is the preparation for litigation. For every hour I'm in a court hearing, I've prepared for that 1 hour, 2 to 3 hours. So all these things that may look easy in a courtroom, they're not easy. They require a lot of preparation. So we're not afraid to put the preparation in, and we have the team to put the preparation in. So when we go to a courtroom, we have our exhibits prepared, we have the game plan in place. Our clients, for the most part, well, no one can ever feel ready for litigation when you're a client, but for the most part, they feel prepared and they're ready to go. The client is in on the game plan from day one. So we have the theory of the case, the client is informed on that. The client, and many times, has helped us select what exhibits we're going to put before the judge. So it's a cohesive plan, and we execute on that plan. I'm a big believer in preparation, and that there can't be too much of it, especially when you're litigating. But preparation for litigation starts out the moment that case is file stamped in court, because it's at that moment that your judge is assigned. And so other strategic decisions have to be made the minute you get the judge assigned, because you don't know if your case is going to court. And if it is, you want to make sure that you're in front of a judge who you believe will give your client a fair shot. And it's only at the outset of the case that you can have any influence on which judge is going to hear your case.